We'll now move forward to our next part of today's panel, namely ESG-related supply chain arbitrations on consolidations and joinders. Specifically, we have Adolf Peter and Alice Fremuth-Wolf, who will be speaking to the topic now. Alice has already been introduced and, of course, is one of the co-organizers and participants of last week's panel. Needs no further introduction, so just very briefly to introduce Professor Dr. Adolf Peter. As you will notice already from his titles, alongside the masochist endeavor of writing 2 doctoral theses, Professor Dr. Adolf Peter has pursued both an LLM and an MA degree and is now Associate Professor at the Shanghai University of Political Science and Law, with a focus on international arbitration, corporate governance, ESG, supply chains, and EU law. So specifically the topics that we are talking about today. So he is predestined to address these issues. He also practices alongside his academic work as international off-counsel at Wöss Partners and is listed as arbitrator in multiple arbitration institutions, as well as with the European Commission for Trade Disputes with Third States. Without much further ado, Adolf and Alice, you have the floor.
Thank you so much, Marcus, for your very, very kind introduction. Let me first share my PowerPoint slides. I'm going to talk about supply chain arbitrations. I want to start first with some practical examples for construction supply chains and automotive supply chains, and then I will move to the arbitration topic, supply chain arbitration topic. In construction supply chains, we typically have build-only model or the design-build model. What's the difference here? Here in the build-only model, the employer would usually have 2 contracts with the main contractor and with the designer, and then you have several tiers of subcontractors and lower tier subcontractors. I mean, this is a very simplified graphic here, of course, because it's in reality much more complex, but this is for easy understanding. And that the design-build model, which is used nowadays very, very often, where the main contractor is basically also responsible for the design. So you have here these tiers: employer, main contractor, subcontractors, and lower tier subcontractors. And please keep this in mind for later on, because we're gonna need this structure: employer, main contractor, subcontractor, and lower tier subcontractor for the supply chain related arbitrations. So automotive supply chains, it's here on the graphic. Usually you have here an OEM. So this is the car manufacturer, and usually you have 3 tiers. 3 tiers of suppliers. First tier of suppliers, there's a direct contract between the car manufacturer, the OEM, and the tier 1 supplier, which supplies systems, modules. As an example, engines, brake systems, or infotainment consoles. Tier 2 suppliers, they're supplying the components. Components, for example, integrated circuits. So very, very important, usually in a contractual relationship with the tier 1 supplier. And then we have the tier 3 suppliers who are providing the raw materials, parts, for example, screws and these kind of things. Of course, then an OEM would have typically a contract with a dealership, and then we have the customer. So this is the complete, also very simplified, of course, automotive supply chain. So having this in mind, I know you're now very, very keen on practical examples. Where this supply chain related arbitrations could really happen, in particular in relation to ESG related supply chain arbitrations. And we have here a case, a brand new case. To my knowledge, it's not yet it's all very, very confidential, and it's not yet an arbitration or litigation, but I think this is all planned. But it was a media release last year, where Borealis, this is a very, very big Austrian chemical company. It's owned by the major oil and gas multinational OMV that is seated in Vienna. And they had a project. Or they still have a project, I should say, a construction project, the building of a plant. And they had to halt. They had to stop this project for several months because of ESG-related allegations. And this concerns the S, so the social component in ESG. The allegations, they were in relation to social fraud, in relation to human trafficking. Borealis contractor mentioned, okay, we're not responsible for that. They blamed subcontractors. So this is actually, again, this typical situation that we have here, defaulting subcontractors. And so this is exactly now the situation, what we're looking for, what is now getting more and more problematic, ESG-related claims. I don't have to tell no one what that means if you have a halt of this production for several months, major delays of the whole project, potentially, Herfried, I think you can confirm that, potentially major damage claims involving multiple parties, because what will happen here is, let's go back here, that the employer will of course sue the main contractor. The main contractor is of course mainly responsible for the whole project, and there will be recourse claims against the defaulting subcontractors. So this is basically a very good example of an ESG-related claim, and of course the same thing also can happen with environmental issues, GHG emission reductions, and these kind of things. So you need to be very careful, because NGOs, they like Greenpeace, they're very alert. There's now climate litigations everywhere. We heard that last week as well. In particular, I want to mention the Total Energies case, where Greenpeace and other NGOs, this is a greenwashing case. There are greenwashing allegations, I should say, against Total Energies. Yeah, and so this is getting tremendously important, and companies need to be aware of that. So how to deal with this situation? Of course, you need to have contracts, and I also talked about that already last time, contractual cascading. So a company will have to have in place codes of conduct, ESG-related clauses. And here you have a couple of models, how you can do it. Express terms model with representations, warranties, and covenants, where you have those clauses directly in the main contract, for example. Or you can use the reference model, where you just refer to a code of conduct, and make it legally binding, of course, along the entire supply chain, because this all has to be passed on. That's why it's called contractual cascading. It needs to be passed on until the last supply chain member in the last tier. Then, of course, codes of conduct may also be signed directly. What happens in the case of non-compliance? First, of course, remediation efforts in a second step, and that's what we had also in this Borealis case. First, we had a suspension, and then, of course, because in the case of ongoing violations, so if they are very material, then only the termination remains, and this needs to be done. And in the Borealis case, actually, we reached the stage of termination. And ladies and gentlemen, more than 80%. You can read everything, is all publicly available. You can read it on the media release on the Borealis homepage. We had here a retender of more than 80% of the whole of the whole project, a retender process. So that adds basically to the potential damage claims. So it's really immense, yeah. And I have here several examples of what can happen in terms of breaches of material ESG-related provisions. Of course, this Borealis example, this is the delay, yeah. So violations against ESG regulations, provisions, for example, contained in codes of conduct, they may lead to delays and have damage claims. Reputational damage, yeah, reputational damage may actually cause pecuniary damage because a company may lose clients, may lose business projects, and all these kind of things need to be thought about. Yeah, goods may be deemed defective, so be careful. Check your contracts. Goods may be deemed defective if they don't meet certain ESG standards. So this is all nowadays needs to be one need to be clear. So let's move to the actual topic, multi-party arbitrations. And of course, because of these multiple tiers, we will have multiple parties involved in those arbitrations, and arbitration is the means to go for, because this is all international. These are all international parties from different countries, and of course, because of the New York Convention, I don't have the time to go into the detail as far as the New York Convention, but it has to do with enforcement worldwide. That's why arbitration is basically the ideal means of dispute resolution in this kind of disputes, and most effectively are consolidations and joinders, because in consolidations you basically combine several arbitrations. It can be one, can be 2, 3, 4 arbitrations. I'll give you some examples later on, some practical examples. You just combine this to one arbitration, and we're gonna have only one arbitral tribunal that decides on that case, basically. Yeah? The joinder actually, so this is the combination of several different pending arbitrations. Joinder is basically that additional parties join one pending arbitration. Yeah? For example, a typical example would be a subcontractor if there's recourse claims by the main contractor. So, but what's the purpose? The purpose of the consolidations. Why do I want this? Yeah? And the most important reason is to avoid contradictory and inconsistent arbitral awards. That's really the most important reason. I'll just give you an example. If you have now an arbitration between the employer, yeah, and the main contractor, yeah, and you have a second arbitration between the main contractor and the subcontractor, and the subcontractor is the defaulting party here. It's in particular in the interest of the main contractor to have here consolidation to avoid contradictory awards, because in the first arbitration, maybe the employer wins against the main contractor. Yeah? So in the second arbitration, we don't have a consolidation. What happens if the main contractor loses against the subcontractor? Yeah? Cannot assert its recourse claims, because the second arbitral tribunal interprets some laws differently, sees certain facts, establishes certain facts differently. So in particular for the main contractor, this is very dangerous. So some other advantages, of course, include efficiency considerations. Expert witnesses only have to attend one proceeding, have to only prepare one set of reports. Witnesses, of course, cross-examinations only have to take one in one oral hearing, and so on. And legal fees, of course, will be saved. Yeah, I don't want to go into too many details because I'm almost running out of time. Very important is still the consent to consolidations and joinders, because we have the consensual nature. So we need the consent of all parties involved. And this consent can either be provided expressly or impliedly. So most of the time, when you look at arbitration clauses, you don't have nothing in. It's just silent. And if it's like that, you have certain, then you need to take a look at the arbitration rules, so the applicable arbitration rules. And in particular, so if it's silent, if it's not forbidden to have those consolidations or those joinders, you look at the respective applicable arbitration rules. And if the certain criteria, and I'm going to show you some of those criteria a little bit later on, if certain criteria are fulfilled, then you may apply for a consolidation, and will highly likely this consolidation will even be granted against the objection of a party, because the party already, there's an advance consent by consenting to the application of those arbitration rules. So the last slide before I hand over to Alice is incompatible arbitration agreements. Of course, consolidations you only can have if the arbitration agreements are compatible. And that means it cannot be that one arbitration agreement, for example, refers to VIAC arbitration rules and the other one refers to SIAC arbitration rules. The seats of the arbitration need to be the same. Seat of arbitration is the applicable arbitration law, of course, needs to be the same. The languages of arbitration should be the same. Different numbers of arbitrators would create a major issue. Maybe we have a sole arbitrator in one arbitration, three arbitrators in another one. It's just not compatible. You cannot have it. You cannot have a consolidation. Yeah, and last but not least, expedited proceedings. You know, you have the difference between standard and expedited proceedings, and that would also create issues it would lead to incompatibility. Okay, and before I go to technicalities as far as some provisions, concrete provisions in arbitration rules, I hand over to Alice, as she was the Secretary General of the VIAC, and for that reason alone, she's the best person to discuss some practical issues, because it's my understanding that the VIAC rules, they are very, very flexible, in particular as far as joinders are concerned. Please, Alice.
Okay, so thank you, Adolf, for setting the scene, and I have now a little bit more boring task to guide you through sort of the VIAC rules, which are really particular on the issue of joinder and consolidation. The rules were amended first in 2013 to include these provisions, and I was involved in my role as Secretary General back then in this revision process. And so I really know why and what was the reasons why the VIAC has introduced this sort of really broad joinder provisions. Well, it's worthy to note that the previous rules were very, very strict, making it almost impossible to have joinders. So, and in order, if you read the joinder provision of the VIAC rules without that background, and for these reasons, we have also published a handbook with a really extensive guideline how this provision is to be understood, one could have the feeling that, you know, everyone can be dragged into VIAC proceedings. Of course, this is not the case, but, you know, on the word of it, the provision is so broad that theoretically a lot of various joinder possibilities are out there and can be fitted under this VIAC rules. Unlike, for example, the existing ICC rules, and I've prepared in the slides that I'm happy to share with the participants later on, you know, a comparison of the ICC of the VIAC rules, where you really can see how the differences are. So, under the VIAC rules, who can request a joinder? It can be either be the party to a pending arbitration or a third party wishing to join. And who is deciding the joinder request? Under the VIAC rules, it's always the arbitral tribunal on the admissibility of the joinder and also of the manner of such joinder. Unlike in the ICC, where it's usually the court under Article 6, you know, taking a stance on this. Well, under the preconditions that, of course, all parties have been heard, including the third party to be joined, and considering all relevant circumstances. And, you know, under these sort of prerequisite, considering all relevant circumstances, of course, the arbitral tribunal takes into account the arbitration agreement. Is it binding? Was it an implicit or explicit consent? The will of the parties, also the third party, the underlying legal relationship, confidentiality interests, the interest in speedy and cost-efficient decisions, and, you know, the overall resolution of the dispute, which especially in these supply chain contracts is sort of the goal, and the avoidance of contradictory decisions, as Adolf has mentioned. Well, the prerequisite, of course, is, and then we have to go back to the drafting process of these kind of supply chain contracts, that ideally you have identical clauses in the various contracts, or one model clause that, you know, is contained in a sort of framework contract that binds all the relevant parties. And if you have this, you really avoid unnecessary sort of discussions when it comes to, you know, defining what was the will of the party. Having said that, it means that the arbitral tribunal has to be established already, because otherwise it cannot decide. I'm just saying quite quickly, there are two different manners: a simple request and a request by statement of claim. The difference being, when you request a joinder with a statement of claim, then this additional third party really wants to become a full-fledged party of the pending arbitration proceedings. But under the VIAC rule, as I mentioned, also all other forms of joinders are possible. And because we really wanted to make sure that we don't restrict ourselves to certain national domestic legal concepts, such as Nebenintervention in Germany, Austria, Switzerland, or intervention forcée, volontaire under French law, or vouching in the common law, but to really open it up and make it possible. And that's one of the advantages of arbitration. And we didn't want to cut it on the joinder level, that the parties may decide, and you have this flexibility. So even amicus curiae interventions are possible under the VIAC rules, even if this is not a concept that is known under sort of Austrian law. And I'm not going into detail on that. If you want to do it with a statement of claim, you have to follow, or you have to provide some additional possibilities. I just want to mention very quickly the appointment of the tribunal, because this is very important. As I mentioned, under the VIAC rules, the tribunal decides. So what you do, if the request for joinder with a statement of claim was filed prior to the constitution of the tribunal, the third party to be joined will participate in the constitution of the tribunal according to Article 80, which regulates the multi-party arbitration and the arbitrator appointments under these rules. Okay, so now the tribunal is constituted, and this tribunal then decides that the prerequisites actually of the joinder are not met, and returns the request for joinder with a statement of claim to the Secretariat for separate proceedings, and then continues the proceedings initiated. The problem then is, and we have resolved it in the following way, is that the now continuing tribunal has been constituted with the aid of a party that is no longer a party. And just imagine that, you know, the respondents had to agree on a joint arbitrator under the multi-party rules, but they could not, and therefore the VIAC board stepped in, appointed one for them. But now this one party, respondent party, is no longer part of the proceedings, and the remaining party could claim, well, I want to have my own arbitrator. So in that situation, if that happens, the board may order a new appointment of the tribunal in order really to guarantee the remaining parties their right for a tribunal. So what happens if the request for joinder was filed after the tribunal was constituted? Well, there's actually only two possibilities. The third party will have to accept the already constituted tribunal, or all parties agree on the new constitution of the tribunal, because there's no revocation of an existing tribunal foreseen under the VIAC rule. And now I just wanted to give you some examples of existing cases, what had been decided under the VIAC rules. So in one case, a respondent in the answer of the statement of claim submitted a joinder request against third party, and the third party knows if it was a third party notice of respondent against the third party, which was a sub-supplier of respondent, and therefore a request to join the proceedings on the side of respondent. It was a warranty claim in a supply chain contract, but it could also be this case could also be imagined in a product liability case. Or another scenario was that the third party submitted a joinder request against one or both parties in pending proceedings, sort of in the form of a cross claims, meaning that respondent 1 in proceedings 1 filed the joinder claim against claimant 2, sort of as which was the third party, which was the parent company of claimant 1, because claimant 1 was again in liquidation. In that case, the third party was admitted as cross-claimant in proceedings 1 on the side of respondent. Or last but not least, the respondent or a claimant may submit the joinder request or a claim against the third party in the course of the proceedings. So there was one case where the third party was merely requested to join as an assistant, and that was granted, but only was allowed to make written statements on behalf of respondent without being without the award being binding on the third party. There was also one case where an amicus curiae sort of form of third party intervention was allowed, or as an intervener, sort of in support of a party, but again without being an actual party. Good. This is just the overview and comparison. You see that the ICC has sort of the concept of additional parties and sort of multiple contracts, whereas all this falls under the very simple provision of the VIAC rules. And when I said that the VIAC rules are very broad on the joinder side, on the consolidation side, the VIAC rules are very conservative, meaning, first of all, it's decided by the VIAC board, again, after hearing all the parties and the arbitrators that were already appointed, and again, considering all the circumstances. And it is a very limited sort of consolidation, because it was felt that the parties can always agree on consolidation. And since the prerogative of party autonomy prevails in arbitration, we felt that the institution should not force parties to consolidate if they really do not want. Of course, we all know that some parties play bad when it comes, that it could be detrimental to them. So we said, okay, either all parties agree, or you can find this sort of implicit agreement in the sense that they have appointed the same arbitrators, which is an indication that they want to have it decided jointly. And this is something that is in addition, all arbitration agreements, the seats of the arbitration has to correspond. Because if you have different seats, then this is unreconcilable. But again, the parties need not be identical. Not all parties need to agree explicitly if they have appointed the same arbitrators. So yeah, basically coming back to the joinder, when I said if the tribunal has decided that the joinder is not granted and submits it for separate proceedings, then this party theoretically has another possibility to simply request the consolidation of the proceedings through the back door. Okay, over to you, Adolf, and I'll come back to the Singapore proposal at the very end.
Okay, thank you very much, Alice. I just want to talk about some concepts. The first concept is the series of related transactions. And we typically have this concept in the rules of the Hong Kong International Arbitration Center, but also in other arbitration rules, for example, the SIAC Arbitration Rules, or in Chinese arbitration. Some of the Chinese arbitration institutions also have this. And as far as I'm concerned, and as far as consolidations is concerned, I think this is the most promising criterion to actually allow consolidations against the objection of a party. If you're dealing with multiple parties, like in this construction supply chain or automotive supply chain scenario, if you're dealing with different contracts, but you have always it's relating to one project. And of course, the arbitration clauses, the arbitration agreements, they need to be compatible. That goes without any saying. But as we see here, Article 28.1, we just briefly go over that. It says here in paragraph C, the claims are made under more than one arbitration agreement. But it must be compatible. A common question of law or fact arises in all of the arbitrations, so it must basically relate to one and the same project. And if we have some ESG-related claims, for example, like in the Borealis case, this should definitely work. We have to have this series of related transactions, like in this construction supply chain scenario with the employer, the main contractor, and the subcontractor. And we have here really, I digged basically a very, very old case, from the year 2000. It started back then already. This is a decision from the Hong Kong Court of First Instance, and it relates to the Hong Kong Arbitration Ordinance. So it does not relate directly to the Hong Kong Arbitration Rules, but it's very, very similar because the Hong Kong Arbitration Ordinance at that time in force also mentioned this series of related transactions. And as you can see here, we have here several arbitrations. We have main contractor that applies actually for the consolidation in this construction supply chain. And we have two subcontractors, and we of course have the employer here involved. And the court clearly confirmed, the Hong Kong court held that the two subcontracts, they flowed from the main contract. So there's a direct relation. I mean, because it's subcontracts, they're basically mirroring the most important provisions of the main contract. So a quote here, flowed from the main contract. All the three contracts involved, so main contract and the subcontract, the two involved, would have to be regarded as one series of transactions. And the terms to the payment in the subcontracts were back to back, and so on. So the court actually refers to back obligations, like you do typically have in a scenario involving main contracts and subcontracts. So this is a very typical example. Another one, a more recent example, again, in relation to the Hong Kong Arbitration Ordinance, again, in relation to the series of related transactions. And again, a Hong Kong court, and we were dealing here again with several arbitrations, and also with employer, with the main contractor, and a consultant was here also involved, and subcontractors, and it was also successfully consolidated. And the court found common questions of law and fact. The rights to relief claimed arose out of the same transaction or series of transactions in the project, in one and the same project. Here it was the construction of a bridge. So you can see this is quite promising for our case scenario with the construction supply chain, with the automotive supply chain, also of course with the Borealis project. I do not know if they have arbitration agreements because it's very confidential. It's not publicly available, this information, but it would definitely fit. And it fits also to for example, cases in relation with in connection with GHG emission reduction. Because I predict one thing. This Borealis case deals with the social component of ESG, but I think in the future, I honestly believe that such project halts, it could also be if for example, some subcontractors, I don't know from which country, I don't want to talk negative about any country, if they absolutely do not adhere to standards as far as GHG emission is concerned, and the supply chain leader has a very strict standard, net zero standard, and they violate this net zero standard. And if the supply chain leading company doesn't do nothing against that, but of course it reports, so then it's publicly available, this net zero standard is in relation to GHG emissions, then of course again NGOs and other entities, individuals, they could come and that could potentially lead to litigations, and those litigations they could then cause problems in the supply chain, and this could then be the trigger for supply chain arbitrations. So GHG emission related clauses, you will find them more and more in the future, and I think really it will be in the future also the cause, for example, of delays of projects because of construction halts and these kind of things. So I think what we see now with Borealis in relation to human rights issues in the future, we're definitely going to see that also in relation to climate issues and other environmental issues. That's my prediction. Yeah, just very, very brief. SIAC, Singapore International Arbitration Center, has here also very, very detailed rules for consolidations. And of course, it refers here in paragraph C also to a series of transactions, and the arbitration agreements, of course, must be compatible. So it's very, very promising. If the parties did not agree upon nothing in the arbitration agreement, of course, it will not work. If the arbitration agreement says no consolidations are possible, then it does not work. Yeah? Because party autonomy, that's the most important thing in arbitration. So very interesting for those of you that are not so familiar with the Chinese arbitration scene. I found in the SIAC Arbitration Rules. Yeah, they just brand new now. The SIAC Arbitration Rules is the China Maritime Arbitration Commission, yeah, headquartered in Beijing. And I mean, they are not only doing maritime cases, they also do normal commercial arbitrations. And they have here as well a very, very up-to-date and modern rule provision for consolidations, very, very detailed. And what we also can find here, of course, in paragraph D, is again the same transactional series of transactions. So China Maritime Arbitration Commission. Yeah. And CEAC, the most important, actually, or I should say that the most known Chinese arbitration institution is, of course, CEAC, also headquartered in Beijing. They also have a representative office in Vienna, to my knowledge. And they actually do not have this series of related transaction provision in, but they have something else, ancillary contracts. And that's just wanna in a couple of sentences talk about ancillary contracts. The most important example I gave you here, some are collateral warranties. Then this would, I mean, anyone in the construction, as a construction lawyer, you would know what a collateral warranty is. This is something where the subcontractor has a direct contract with the employer, which is usually not the case, but here with a collateral warranty that creates a contractual relationship between the employer and the subcontractor. A collateral warranty mirrors the obligations of the subcontract. So you could consolidate two arbitrations, one arbitration between the employer and the subcontractor, and the other one between the main contractor and the subcontractor from the subcontract. Yeah, about this clause, this is, don't want to go into many details. If you really want this clause, you please do not hesitate to contact me, so I can explain that a little bit more in detail. I see that my time is unfortunately running out. That's why I cannot go into any detail anymore as far as my template clause is concerned. take this as a starter, yeah, because every case is different, every supply chain is different, but this is I think a very good starting point. And it also here only the third paragraph, it says here clearly it's basically the cascading of a dispute resolution clause, so that the same clause will be passed on in terms of consolidations, paragraph 1, and joinders, paragraph 2. Yeah, so it would be passed on the entire supply chain. Yeah, and that's all from me. Alice, I think you have still some very interesting perspectives on the SIAC consolidation.
Well, I just, as a wrap up, and maybe you can again stop sharing, I have one remaining remark just to show you how that there was a very innovative actually initiative by the SIAC in 2017, which sort of ultimately failed. And I'm saying this because I've seen in my VIAC experiences a lot of pathological clauses. And when it comes to multi-party, multi-arbitration, multi-contracts, parties might want joinders, but they have conflicting arbitration agreements in that sense that they have different institutions. For VIAC, it happened always with VIAC and ICC Austria. You know, people could not sort of differentiate. And so what SIAC came up with was the proposal for a joint protocol on cross-institutional consolidation, meaning that even if two institutions were named, consolidation would be possible, and was an invitation to other institutions to sort of join into this protocol, to sign it, and then form joint committees who in that case would decide who is taking the lead in the consolidation. And I'm saying this without reservation. It was a great idea by SIAC, of course, with, you know, back in mind that a lot of consolidations would then happen to SIAC. But the underlying idea was really great. Ultimately, it failed because there were too many issues open, sort of on the enforcement level. Also, what happens if the joint committee cannot agree on which institution should take the lead? Would then there be no consolidation, even if the parties had wanted it? Concerns about cybercrime and so on and so on. So a great idea, but it actually did not come into life. Maybe it's going to be revived now in, you know, in this discussions that we have with all these supply chain arbitrations. That was actually the end of my presentation, and I think also of yours. Do you want to have a last word, Adolf, or shall we close it because we're already?
I think we'll wrap it up here. Thank you so much, the two of you. Thank you for sharing your insights. It was super interesting to see all of what is out there, particularly this rich flavor of different provisions depending on the institutions, the various focus that's been laid on these issues. And